Are salaried employees entitled to overtime pay under federal law? In recent discussions about labor laws, a pressing question has emerged. Are salaried employees entitled to overtime pay under federal law? This topic has gained attention as many workers seek clarity on their rights. With recent changes in legislation, understanding this issue is more important than ever. Under the Fair Labor Standards Act, the entitlement to overtime pay for salaried employees depends on their classification and job duties. Generally, the Act requires that covered non-exempt employees receive overtime pay. This pay is calculated at a rate of 1.5 times their regular pay 4 hours worked over 40 in a work week. However, many salaried employees may not qualify for this pay due to exemptions. Salaried employees can be classified as either exempt or non-exempt. Exempt employees, such as those in executive, administrative, professional, outside sales, and certain computer-related roles, do not receive overtime pay. This means that regardless of how many hours they work, they will not receive additional compensation. On the other hand, non-exempt employees are entitled to overtime pay, even if they are salaried, if they meet the criteria set by the Fair Labor Standards Act. To qualify as exempt, salaried employees typically must be paid on a salary basis at or above a specific minimum amount and perform certain job duties. If these requirements are not met, the employee may be classified as non-exempt and thus eligible for overtime pay. For non-exempt employees, overtime pay is mandated for hours worked beyond 40 in a week. This rule applies to all non-exempt employees, whether they are paid hourly or on a salary basis. In addition, recent federal legislation has introduced tax provisions allowing workers to deduct a certain amount of qualified overtime compensation from their income. For tax years 2025 through 2020, this deduction can be up to $12,500 for individuals and $25,000 for married couples filing jointly. However, this deduction applies only to overtime compensation required under the Fair Labor Standards Act and does not extend to overtime paid due to state laws or collective bargaining agreements. In summary, whether salaried employees are entitled to overtime pay under federal law depends on their classification as exempt or non-exempt. Exempt salaried employees do not receive overtime pay, while non-exempt employees do. Recent tax law changes provide a deduction for qualified overtime pay but do not change the fundamental rules regarding overtime entitlement. Understanding these classifications is essential for employees to know their rights in the workplace.